So hello, good morning in Europe and good evening in Australia. It's with great pleasure that I welcome you to this webinar co-hosted by CONREP and the NCCR on the Move. CONREP is the abbreviation for Comparative Network on Refugee Externalization Policies. It is a Jean Monnet Erasmus Plus network between 6 universities in Australia and in Europe. That is headed by the University of Melbourne in Australia. The network was established in 2018 and studies from a comparative perspective the impact and effects of refugee externalization policies by the EU and Australia. By refugee externalization policies, we mean all those laws and practices that are developed to deter or prevent asylum seekers and refugees from access to domestic asylum systems. In most cases, this occurs by invoking explicitly or implicitly the responsibility of another state for dealing with persons seeking protection. In the absence of common rules on the sharing of responsibility in international refugee law, these externalization policies amount to a unilateral measure for responsibility shifting. Importantly, this political process, if you want, of responsibility shifting does not overtly contest the externalizing countries' commitment to refugee law. So countries which externalize frequently do not break the law, but rather develop sophisticated legal constructs that help reduce the portent of their obligations under the law. And our seminar today deals with one of the oldest instruments of refugee externalization and one which has evolved and traveled dynamically across time and space. This is the notion of safe country policies. We have the great pleasure to introduce innovative research conducted by Frowin Rausis, a PhD student in the NCCR on the Move at the University of Lucerne in Switzerland. Frowin has just finalized a database documenting the worldwide diffusion of safe country policies from their inception until today. Frowin's presentation will be followed by two lawyers, Daniel Ghezelbash and Gregor Noll. Daniel Ghezelbash is Associate Professor and ARC DICRA Fellow at Macquarie Law School in Sydney, Australia. Daniel will comment on the spread of safe country policies from a legal perspective and the prism of what he terms hyper-legalism. We will also discuss some connections between Frowin's research about the spread of safe country policies and Daniel's book, Refuge Lost, in which he analyzes legal transfer between the US and Australia regarding immigrant detention, extraterritorial processing, and other restrictive asylum measures. Last but not least, we have the great pleasure to welcome Gregor Noll from Gothenburg University in Sweden, who is also a member of the CONREP network. And Gregor was among the pioneers studying what he termed visions of the exceptional in refugee law, that is also legal constructs that are designed to circumvent and restrict access to the law. We have asked the speakers to hold relatively brief presentations, which will be followed by a panel discussion before we open up to the Q&A. You in the audience should see a Q&A button on your Zoom screen. So we welcome any comments and questions through this tool, and we will collect them and engage in a Q&A at the end of the session. So without further ado, I would pass the floor to Frowin, who will start off with a presentation of his database of safe country policies.
So thank you very much, Sandra, for these introductory words. Thank you very much to CONREP and the University of Melbourne for making this event possible. My name is Frowin Rausis. I'm a PhD student at the Department of Political Science at the University of Lucerne, a research fellow of NCCR on the Move, and currently a visiting scholar of the Center for Advanced Migration Studies at the University of Copenhagen. Of course, it's a great honor for me, and I'm very grateful to speak among such excellent scholars in his field of research, and trying to share my screen. I would like to speak today about and visualize the global spread of safe country policies based on a new data set that I made. When we speak about safe country policies, we speak about access to asylum. And when we speak about access to asylum in these days, in face of the war in Ukraine, it almost seems to me like speaking about a non-issue. Just some quotes currently from Poland and Denmark. We will do everything to provide safe shelter in Poland to everyone who needs it. Quote from Minister of Interior and Administration of Poland, or I have signaled very clearly that the Danish door is opened, statement by the current Minister of Immigration and Integration of Denmark. However, only a few years ago, when the European Union tried to set up a relocation program in 2015, from the same direction, we heard quite different tones. I say very clearly that I see no possibility at this time of immigrants coming to Poland, was a statement of the then former Minister of Poland. And in light of the huge influx in Europe these days, there's a good reason for us to tighten rules, statements by the former Minister of Immigration and Integration of Denmark in 2015. So it seems that access to asylum has indeed been an issue and is still an issue in refugee studies. In fact, the lack of legal access to asylum was declared to be perhaps the single most prominent topic in refugee studies for the past 3 decades. And host states, as we know, have adopted a wide array of measures to hinder people from reaching national territories. But beside these physical barriers to hinder people access national territories, they have also adopted procedural barriers for the persons who have crossed these physical barriers and entered national territories. And the most prominent and the most important probably are the safe country policies. So safe country policies can be defined as policies that allow states either to reject an asylum application by arguing that the applicant originates from a safe country of origin, or by shifting responsibility for examining an asylum application to another country that is deemed to be safe. So there are key elements of what has been called the architecture of repulsion and the deterrence paradigm that was found to be dominant in asylum governments in the global north. So clearly, by allowing responsibility shifting, these policies are fundamentally challenging also the principle of responsibility sharing. And while the importance of these policies has been recognized both for host states and people seeking protection, the research currently is mostly based on the global north, on the legality of these policies, in the effectiveness, on the safety of these policies. And I found that we actually have really striking lack of systematic information on safe country policies in all world regions. For this reason, I have set up the Safe Country Policies Dataset. This dataset consists of safe country policies and national asylum frameworks based in 195 countries from 1951 until 2021. It is based on an extensive online data collection of me and 2 research assistants based on national and international law databases. And it is about the law, it's about policies, it's not about the practice. And finally, it has been important for me to make this publicly available, which I did at the beginning of this year. So I think we should distinguish 4 types of safe country policies. The first has a bit of a different way, where a bit different mechanism than the other ones. It's a safe country of origin policy, because in this case, a country formally accepts the responsibility for an asylum application, but then usually rejects the application, often in an accelerated procedures, by arguing that the person originates from a country that is generally deemed to be safe. Then we have the first count of asylum policy, in which states deny access to refugee status determination and shifting responsibility by arguing that the person has already granted protection in another country that is found to be safe. Most prominently, possibly the safe third country policy, on which is more important, possibly also because it affects a much wider array of people, people that have any form of link and connection to another third country. I have distinguished substantial person link, for instance, a family link, or even weak or coincident links sometimes are viewed sufficient. For instance, a person has only transited or stayed for a very short time in another country. Then I follow the ones who said that we actually should distinguish the safe fourth country policy from what is sometimes also mixed up with the safe third country policy, namely agreement policies, the policy that is based on bilateral agreement with another country that is seen to be safe, irrespective of whether the person has any link to this other country. So Australia, or more recently Denmark, are countries that have adopted this policy. So before I want to show the spread of these policies, I think it's important to think about the adoption of national asylum frameworks, because only a state that has in the first place adopted a national asylum framework and recognized responsibility has then any incentives to reduce responsibility, to shift responsibility to another country. So we can see that about 2/3 of the country in the world, the green ones, have adopted a national asylum framework, whereas 1/3 of the countries, mainly in Northern Africa, in the Middle East, or in Asia, have not done so, and therefore no incentives to adopt a safe country policy. When we look at the temporal patterns of adoption, we see that in the late 50s, countries started to adopt national asylum frameworks. And then with some time lag of 10, 20 years, in the late 60s, 70s, and 80s, countries started to more and more to build up, like in a second legislative wave, safe country policies, different types. First, the first country of asylum policy, then the safe third country policy, the safe country of origin policy, and most recently, and only adopted by very few, the safe fourth country policy. When we look now at the spread of these policies, starting with the safe country of origin policy, we can see here that this policy, which has been first adopted by Switzerland in 1990, has been very successful and spread across Europe, but only very few states, Canada, they have now taken it back, South Korea, Timor-Leste, and Angola, most recently, have adopted these policies. So you can see a very clear geographical clustering and focus on Europe. When we look now at the first country of asylum policy, we can see that this one has spread much wider, not only across the global north, but also, as we can see, through countries of Central Asia, some countries in Latin America, and a remarkable number, nevertheless, in Sub-Saharan Africa, who have adopted this policy. A similar picture we can see with the safe third country policy, a bit less, that spread a bit less, but again, we can see almost all countries in Central Asia, some countries in Latin America, but specifically quite a number of states in Sub-Saharan Africa have adopted this policy, and we would see even more if we would also count the countries who adopt this policy in practice, even though that it's not formally in the law. Quite different, we can see the picture here with the Safe Country policy, which is clearly the exception, not the rule. Here we have 4 countries, Australia, the US, Israel, and Denmark, who have adopted this policy at some time. So I think just to finish up, I would say that, of course, more research is needed, and I'm working on part of it about what are the drivers of the mobility of these migration policies, what are the mechanisms of diffusion, so to speak, how are they put in practice. But I think what we see very clearly is that there is some interdependence between the countries. And I think we can nevertheless mention like 3 different trends and implications. First, on the policy side, I would say that the newer types of safe country policies tend to increase the range of people affected while decreasing the level of responsibility towards people seeking protection. When we look at the effects of people, I would say that the spread of safe country policies tends to force more people to seek asylum in host states with lower protection standards, both on a regional level, but also beyond. And then finally, I feel that we're often left with little less than saying, well, the more restrictive the asylum policies get in the global north, the higher the pressure gets in the global south. I think while this is correct, we should also look at the dynamic more closely. And I would say that the fact that traditional host countries such as Tanzania, South Africa, now more closely Kenya, adopt these policies could mean that the increasing popularity of these policies in the global south could lead to new patterns of injustice among states within regions that host a vast majority, 86% of the displaced people worldwide. So this has been very shortly my presentation, and I'm very curious to hear more from the legal perspective. Thank you.
Many thanks, Frowin, for this very clear presentation of your extremely rich data set, which brings some surprises as well as to the patterns of diffusion, but also the sequence of diffusion between these different policies is highly interesting, and I think gives a perfect bridge to Daniel, who has been thinking a lot about the legal constructs of these policies that preclude access to asylum systems, and how actually they evolve over time and become more and more, legally perhaps impermeable towards what was initially the purpose of the asylum regulations in the first place. So we look very much forward, Daniel, to your comments and analysis.
Thank you so much. And Frowin, I just wanted to congratulate you on a really, really important piece of research. I've been involved in other projects that have tried to map out comparative migration policy across different countries, and even doing it across a handful of countries, usually in the global north, is so difficult. But to do it with such wide reach and such wide coverage is really a great feat, and it opens up so many interesting avenues of research. Today, I'm going to be focusing on some of the legal implications of the safe third country practices, viewing them through the lens of what I describe as hyperlegalism. So this is basically a bad faith interpretation of international legal obligations towards refugees, which kind of pay lip service to those obligations while at the same time denying access to protection. But first, I want to take a step back and situate the spread of safe country policies in the broader context of the diffusion of increasingly restrictive asylum policies around the globe. And this was the topic of my 2018 book, Refuge Lost: Asylum Law in an Interdependent World. And my main argument there was that asylum policies across states are interdependent, and that adoption of restrictive measures in one state can create pressure on other states to adopt similarly restrictive measures, resulting in a race to the bottom that could potentially lead to the end of asylum. And one of the policies we see spreading in this paradigm is the safe third country practices, are so eloquently described and visualized in Frowin's presentation. But I think what I want to focus on, though, is the legal question of how states are getting away with these increasingly restrictive asylum policies under international law. And I'll be answering that with reference to this concept of hyperlegalism, which I will discuss and introduce more in a moment. But to understand hyperlegalism, I think it's important to understand the sort of contradicting motivations which are behind government asylum policy making. So they find themselves caught between contradictory desires in their constituents. The first is a sort of genuine commitment to international law and human rights, and the other is a desire to limit the number of asylum seekers entering the territory. And the solution that many states have come up with is to pay lip service to those obligations while finding loopholes that allow them to keep asylum seekers away. So this can be sort of described as either bad faith compliance or evasion. And this has significant benefits from the perspective of the government. At a domestic level, it can ease the collective conscience of the public and their electors and shut down political criticism. How wrong or how can asylum policies be if they can be ostensibly claimed as complying with international law? And at an international level, it allows states to avoid the costs of outright violations of international law and deflect external criticism from other states and international organizations. So one of the ways that states achieve this is through hyperlegalism, which exploits the gaps in the international protection regime. It involves sort of bad faith approach to interpreting international obligations, which allow for purported compliance with the letter of the law, but in a way which minimizes what are viewed as inconvenient legal obligations in an arguably legal fashion. So hyperlegalism basically takes the idea of legalism to its extreme. So legalism equates morality to rule following. So at the heart of legalism is an inherent belief in rules and the good that flows from them being followed and implemented consistently. But hyperlegalism sheds that foundational premise. The applicability of rules become infinitely malleable, allowing states simultaneously to seek the rhetorical and political benefits of ostensible compliance with international law, while ensuring their actions are unimpeded in practice. And the expansion of the safe country policies is great illustrations of this. So it takes this premise, a contested premise under international law, that persons are not deserving of protection if they can find protection elsewhere. But then it sheds the requirement of what actually constitutes protection and the connection required between the asylum seeker and the country of purported safety, allowing, basically justifying sending asylum seekers to just about anywhere. And so, as I flagged, we see this expansion happening across two different levels. So the first is the connection of the asylum seeker to the purportedly safe country. And here, adopting Frowin's fantastic typology of the different forms of this practice, we see, increasingly tenuous link between the country of safety and the asylum seeker. Moving from having actually secured protection in a particular country to increasingly tenuous links to that country to absolutely no connection with that country with the safe fourth country principle. Sorry. At the same time, we see the reduction in the level of protection that's required under these policies. So again, as we saw on that previous slide, we moved from having already secured protection to now with the possibility of securing protection, but also a reduction in the standard of protection required. So now, as I kind of alluded to earlier, there's no textual basis in the Refugee Convention authorizing safe country policies. So the justification generally focuses on the absence of an explicit right to asylum in the Refugee Convention. And in the absence of such a right, the main constraint is the non-refoulement obligations under Article 33 of the Convention. And the argument goes that as long as people are not being sent back to a place where they face persecution, then safe country policies will be authorized. And the standard that's often referred to is the concept of effective protection, but there's no consensus on what exactly this entails. And that this has given states leeway to increasingly push the boundaries and lower the standard of protection. One of the ways states have done this is by cherry picking specific rights to focus on. And then that was obvious in that justification of the safe country policies that I just mentioned before, where states really just focus just on non-refoulement, and they put aside the other protections and obligations they owe to refugees under the Refugee Convention, and also the other obligations they owe refugees and other people on the move under human rights protection instruments, including the right to personal security, family life and unity, and adequate standards of living. So, we often see these overlooked in the safe country policies. There's also been a progressive lowering of the standards in terms of how these rights are actually protected in the country that's purportedly safe. So in earlier incarnations, there was a focus on the need for legal protection, both in terms of having ratified the relevant international treaties, as well as having domestic implementation of those policies and protection in practice. And more recently, there's a move towards states taking a view that informal or de facto protection in that country, say assurances that people will not be sent back, will be enough to deem a country as being safe. And my home country of Australia has taken this probably to the furthest, to the most extreme level. We had, with our safe fourth country policies, we had some a case in our High Court which found that under the legislative provisions, for a country to be declared safe, you needed all those things I mentioned before. They needed legal protection under international law, under domestic law, and as a matter of practice, people should be able to avail themselves of those protections. And in response, the government changed the legislative provisions, and now there's no requirements aside from the fact that the minister is satisfied that it's in the national interest to declare a country to be safe. And also the legislative provisions explicitly state that there is no requirement to refer to Australia's international obligations when making that determination. And this is the perfect example of hyper-legalism, with Australia claiming the rhetorical benefits of compliance with international law, with a claim that the countries they are sending asylum seekers to are safe, yet it maintains full discretion as to the standard of protection required, reducing it to close to non-existent. Finally, I want to briefly touch on some strategies of, I guess, pushing back and piercing the veil of legitimacy created by hyperlegal arguments. And one of the key or central strategies inherent in hyperlegal tactics is that cherry picking I mentioned already, focusing on one specific provision, claiming compliance with one specific provision while ignoring others to justify a policy. And this can be countered with a good faith and integrated approach to interpreting international law in line with the rules of treaty interpretation in the Vienna Conventional Law of Treaties, and in particular Articles 31 and 32, which require a treaty to be interpreted in good faith in light of its ordinary meaning, in the appropriate context and in light of the objects and purposes of the treaty, but also importantly integrating an integrated approach which takes into account other applicable rules of international law. And we need to execute these arguments in two different forums. One is through strategic litigation, and there have been some successes. The Australian example I mentioned earlier was a success in finding one of these policies to be unlawful, although it did lead to legislative change that gave the green light further down the track. But litigation is just one way of seeking to challenge such policies. And we should also be focusing on cogent delivering eloquent and cogent arguments relating to the legality of these policies under international law to a public audience, and to sway public opinion and create momentum of change. And this is important given that the nature of hyperlegal arguments. They're designed, the tactic is designed to allay the concerns of the domestic public, and by framing things as being ostensibly compliant with international law. And if we can pierce that veil and highlight the inaccuracy and hypocrisy of those arguments, we can diminish the power of such arguments to be used as rhetorical shields and force the public to more fully understand the true nature and consequences of the actions the government is taking. Thank you.
Thank you very much, Daniel, for highlighting the legal complexities behind such policies, and also the possible measures to bring the laws closer to the purpose of an asylum legislation in the first place. I think that Gregor will follow up on this legal analysis, looking also at the international framework for collaboration, the Global Compact for Refugees that has been set up to fill a bit the gap in the international structures promoting cooperation between states, and eventually also an understanding about responsibility and the sharing of this responsibility. Anyways, Gregor, the floor is yours.
Thank you so much, Sandra. It's really very nice to be here, to be joining you, and special thanks to Frowin. Great presentation, great arguments. I really enjoyed in particular your last point on the kind of spread of safe third country within the peripheries in a South-South relationship. It was really amazing to see that kind of argued so carefully. And Daniel, what can I say? It's really wonderful. You basically you really took the floor with a strong argument, a strong critique against what you call hyperlegalism. So what else can I add here? Perhaps an attempt, if I may, to try to see what is happening in safe third country norms spreading right now, and what does it mean. So it's a kind of a third voice to the two excellent voices we already heard here, and I'll try to kind of zoom out a little bit, and I'll try to understand how safe third country norms on a kind of a structural systemic level produce benefits for states in the center. I'm going to use a center periphery terminology here, which seems really important, especially as we are now seeing that the export value of safe third country policies is apparently so great that you see them staged between states that we would think of as periphery states, but of course they are kind of living off kind of more subtle center periphery power differentials. So my presentation is going to be about these power differentials, which are translating into legal differentials, and these legal differentials bring concrete benefits. So the idea is very much as in, for example, outsourcing. If you go to a site of production that makes it cheaper to produce a certain desired resource, you would do that, and you would try to profit from that differential of cost in a kind of an onshore setting compared to an offshore setting. So what we're dealing with here in safe third countries is not so alien to us if we think of, following economic developments, economic reporting in media and so on. Those patterns are very much the same, or patterns that can be usefully mapped onto each other. So what do I want to argue in the presentation? Very briefly, I'll argue that as safe third country norms move a concrete case, the case of a concrete human, from center to periphery, this case encounters, for one, less demanding substantive law. Secondly, it encounters less formal law and more informal law. And thirdly, it encounters less clear forms of attributability under rules of state responsibility or international responsibility. So there are these three dimensions in my argument: less demanding substantive law, less formal law, more informal law, and we can attribute responsibility with less ease as the case moves from center to periphery. So that's fairly simple. So what is happening? What can we observe? As the title of today's seminar already suggests, there's this spread of safe third country norms, and Frowin has made a kind of a very detailed case for exactly how that spread looks. And we could say, if we want to further systematize and clear our thinking on what is happening here, we could say that there's this numerical proliferation of, say, third country norms. You recall the intensification of color in Frowin's graph. From 1979 onwards, basically, the hue of the color grows deeper and deeper. There are more policies adopted, more norms made, and so on and so on. And we should add more treaties concluded among states on a bilateral or even multilateral level that kind of give a legal fabric to the policies pursued. Right. So within that spread, within the numerical proliferation of, say, third country norms, we see the integration of less formalized sets of rules, such as the EU-Turkey arrangement, which is perhaps most famous because it so craftily resists being subsumed under a particular category of law. And therefore, the question of exactly how, in what way is it binding, is a kind of an elusive question. And we can try to kind of hammer it down with formalist legal arguments, but we have to acknowledge that it is designed exactly to serve that function, to leave us with a big question mark about what kind of law is it and exactly how formal is it, if it is formal law at all. So that applies to another body of, dare I call it, law, and those are the global compacts, which are also designed to be using up a terrifying amount of diplomatic resources, as my colleague Brian Gorlick has pointed out in a recent blog post, enormously laborious to get this stuff on paper, without pushing it to a point where you do have a treaty or where you have produced a kind of a legal obligation in any other way. So the question is whether informality is part of the design, and I think we have to respond affirmatively to that question. With each new safe third country norm created and integrated into that web of obligations or quasi-obligations, the complexity of the total web of norms is growing, because we also have to count in what domestic lawmaking says about safe third country arrangements, and with that, each kind of international resurgence of a safe third country norms creates a ripple effect that kind of pulls with it domestic legislation and makes the domestic lawmakers produce domestic law norms in order to make good on the desideratum, the point that one seeks to achieve with the safe third country policy. So with that, we also have a proliferation and growth of actor networks. You will recall that the Global Compact on Refugees is speaking about relevant stakeholders as a particular category of actors which are put side by side with states. To run a quote from paragraph 34 of the Global Compact on Refugees. In this context, it says, and I quote, "States and relevant stakeholders will explore how best to include refugees and members of host communities, particularly women, youth, and persons with disabilities, in key forums and processes, as well as diaspora where relevant." And it goes on, and I quote, "Mechanisms to receive complaints and investigate and prevent fraud, abuse, and corruption help to ensure accountability." That's a nice statement. End of quote. I'm sorry. That's a nice statement, of course, but you see that the level of aspiration of creating binding and functional legal mechanisms to deal with complaints, to deal with the difficult issue of access to justice, where you have a plethora of actors and you don't really understand where responsibility for possible violation of international law is placed, and if you at all can approach one of these relevant stakeholders, which are kind of almost taken hostage in that informal arrangement of the GCR, whether you can use them in your attempt to claim justice. So it's a total image of increasing complexity. Cui bono? Who is benefiting from that? So here I would like to propose a possible way of analyzing that and breaking it down into manageable chunks that we really can bite off and chew and try to understand here. So let me just set out and suggest that we see safe third country norms as a way of constituting externalization by law. And if that is correct in some way, we could see that safe third country norms are making pre-existing center-periphery relationships into legal relationships of a particular kind. So what is that particular kind? The power differential that would exist between any center and a periphery. I mean, a periphery is periphery because it's less powerful than the center. So there's a power differential. And I would add there's also a transformation of that power differential into a legal differential. Think for a minute about metropolitan clauses in human rights treaties, where it's clear that the full amount of rights is only applicable in metropolitan and not in colonial territories of the contracting parties. I mean, that's a kind of a heritage, a problematic heritage that human rights law is nowhere near of liberating itself to, although you have to look in a more sophisticated way for these differentials. Safe third countries are a way of downgrading human rights law in very much an analogous way, analogous to those metropolitan clauses. You find them in other parts of international law as well. Look at the way that international humanitarian law has dealt with the prospect of warfare in the colonies against the original population that the colonizer encounters there. So that's a useful analytics. I don't want to go too far into it, also because with Frowin's argument that you see these relationships exported and taking up its own life in intra-periphery settings, you have to think clearly about how to separate the historical experience from what is going on now while seeing the structural likenesses and analogies. So that's the starting point. So if there's this translation of a power differential going on, and I'm realizing that I should make this short and simple from now on, you have simply three dimensions where there's a kind of a legal rebate system playing out. One is in substantive law, and it's very simply explained. Think about that human rights law and refugee law contains what we call positive obligations elements. So positive obligations are those obligations that invite a state, indeed require of a state to do something actively rather than to abstain from doing something. So usually positive obligations are associated with the question of resources. How much is a state obliged to do under international law is also related to the resourcefulness of that particular state. So law, although stable in a sense, is also internally in flux here and adapts to the particular circumstances where it is meant to be applied. And if you mean to apply it in an affluent state like Switzerland, for example, just to pick an example, you might see that positive obligations are demanding a kind of a one set of one particular form of conduct from an affluent state, and there might be lesser demands on, let's say, a state in the Maghreb, in Tunisia, which is less affluent, which has less resources at its disposal. So you see there's a kind of a differential here between center and periphery that one exploits in safe third country policies. So it is the case that the law to some extent demands less, not across the board. Positive obligations are one dimension of the law. There are negative obligations. Those are meant to stay the same. But you do get a rebate when it comes to positive obligations, and cynically one could say, well, let's make use of that rebate to acquire protection in a more cheap way. And cheap is now not related to the cost of labor in Switzerland compared to Tanzania, but cheap is really because legal demands under positive obligations are less exacting. So that's one dimension. We could go on, think about how proportionality judgments also fit into that description. I'll not bore you with that analysis, but it could be usefully thought of. So you have a kind of a variable geometry, if you so like, and that's not necessarily bad faith. That is, well, that's actually legal positivism, formalism. That's the religion we seem to have been having in international law throughout most of the 20th century, and that's a kind of an outflow of secularization. So here we are. Let me move on to the second dimension, which is the more we move from center to periphery, the less we encounter formal law and the more deformalized or informal law we encounter. And that's simply because states choose to cloak obligations into more political and less legal forms, or in ambiguous forms where you can both have the cake and eat it as you deem fit. Also because international organizations are involved as actors, or other non-state actors are involved, like local organizations, local actors, businesses, and so on. And these, as you know, are harder to compute for an international lawyer, for public lawyers as well, I should say. So you have a deformalization of refugee protection cooperation that adds an exploitable responsibility differential. And we could go on and think a bit about the question of allocation of responsibility as a discrete third dimension of that downgrading dynamics, and we could move into the articles on the responsibility of international organization, the way that direction and control of a conduct that breaches international law is regulated in a rather demanding way when it comes to allocation. So probably it will be very hard to show that a controlled safe third country had no other choice but to violate international law at the behest of the state at the center of the safe third country arrangement. It will be very hard to show that. Therefore, attribution will be rather hard too. And similarly, when it comes to less demanding forms, it will be difficult to delineate the exact responsibility of each of the two cooperating actors in a safe third country arrangements when it comes to aid and assistance in the commission of an internationally wrongful act, for example, a violation of the refoulement rule. So that's going to be hard too. So I think at this point I should stop and just repeat the main argument I tried to make was to say that sorry, I lost my screen now. The more you move from center to periphery, the less demanding substantive law. There's less formal law and more soft law and law whose status is unclear. And finally, there are less clear forms of attribution under the rules of international responsibility. Thank you for bearing with me.
Well, thank you, Gregor, for this very rich commentary or rather analysis. I think we now go over to the panel discussion, and I would invite all the panelists to have their camera on. We can, of course, also, you know, you will have the chance to ask directly questions to each other, but I would like to kick off with one, because this is an encounter between political scientists and lawyers. And in some ways, you have all touched on the two dimensions of the issues. But my question would be, how far can we state that what we are observing here is mainly about an evasion of existing standards of the core? If we take Gregor's center periphery image, so how far do we see an evasion from the high standards of the core that constitute the classic international refugee regime as we came to learn it? Or do we state more a transformation, that the regime is indeed changing? It's not only, you know, being evaded, being circumvented by various legal constructions and also power differentials and pressure by the core on poorer countries. But do the very pillars of this regime change so that this idea that it is mainly based on an individual state's responsibility, that it's very much human rights based on individual rights, that we move towards something more diffuse, that is maybe also more ad hoc towards concrete crises, this core state responsibility towards the individual claim and the spontaneous asylum process is basically on the declining side, and that instead we see something else emerging. And in this context, I would also like to ask you a bit more, all the three of you, about the dialectics between the law and the politics in this process, because initially when the safe third country policy was introduced in Europe, and for example by the Schengen group towards the newly independent countries of Central and Eastern Europe, the first country was Poland that was targeted by the Schengen group. And then there was a ruling by the German Constitutional Court that said, well, we cannot just apply the safe third country rule towards Poland. We have to make sure first that Poland has a functioning asylum system. So states then invested into developing an asylum system in Poland and in the other Central Eastern European countries. And this could be also part of the story. Frowin, you have shown the spread of asylum legislation in your first slide. How far is the spread of asylum legislation itself also motivated by the desire of the core to implement these circumvention policies? And if this is the case, then actually, perhaps, you know, by evading the responsibility of the core at the same time, because there are certain legal safeguards that are nevertheless imposed, these policies also contribute to diffusing the positive substantive elements of the international refugee regime, although as Gregor and I think also Daniel have highlighted very well, at lower standards. So yeah, I would like to hear a bit your reactions to these dialectics between the laws and the politics, and how far we are observing just an evasion, or maybe a delusion or transformation, or more also in parts a promotion of the international refugee regime, but on another level. Yes, so this would be my first question, and we collect also the questions in the Q&A to the audience. Please feel free to feed the Q&A, we will come back to it. So who would like to go first?
Gregor, you go.
Oh, you go ahead, Daniel.
Sure.
You have more interesting stuff to say.
No, I don't think that's true. Sandra, on your first point, I think moving away from the sort of formal legal structures we have now to having a more diffuse or ad hoc approach makes me really nervous. And I've been, I guess, one of the key themes of my talk was, I guess, a critique of international law. But states, we've seen that they always drop to the lowest common denominator, and the fact that they go to such great lengths to still try and provide this veil of legality and try and justify their obligations under international law means that these obligations are still relevant and they're still having an impact. And I think we should hold on to them dearly. I think accepting that a new paradigm with all its shortcomings, clearing the state and starting a new paradigm of sort of informal protection and cooperation, or however you want to call it, as states, given their track record, will immediately drop to the lowest common denominator. And if the legal obligations aren't there, it would be either shutting borders or shutting borders except for certain people in certain countries where they feel some sort of political affinity to. So yeah, so that's the answer to the first part. The second question about, I think you're right. There's a really interesting point about the diffusion of the positive side of sort of externalization, and the diffusion of firstly the development and implementation of domestic asylum policies. But my concern there, at least in the examples that I'm aware of. So I mean, Australia, as a result of Australia's offshore processing policies, with Papua New Guinea and Nauru have created actually what are pretty good RSD procedures, but they only seem to be used for the people that we transferred there from Australia. And so that doesn't rule out the possibility that things will change in the future. And I think maybe down the track, this would be a good development. But I mean, I'd be interested to hear from the other panelists if they have any examples of where that has happened, and also has provided meaningful protection to other asylum seekers in that country beyond those that are being sent there from the countries from the center.
Gregor?
Yeah, great. As to your question, Sandra, on evasion or transformation, I would argue that students of the role of international law in colonial relations, they would immediately recognize themselves and say, yeah, this is, structurally, this is not unknown to us. What you're describing is happening in refugee law and in safe third country policies in particular. So it's hard to argue that we are really in a kind of a very substantive manner transforming anything in international law here. And also with Frowin's help, we realized that, my God, these policies have been around for some while. Some time after, the 70s oil crisis, they popped up and they spread slowly but surely. And then there was this great boost in the 90s as borders were remade, and you had to recreate the Iron Curtain by other means, so to say, to regain a sense of control and pass it on to your populations. it's more a continuity than a radical change, I'd say. I can't really see that we are approaching a point where this is kind of flip-flopping over into a new quality of the refugee regime at large. Because, frankly speaking, let's think of the Evian Treaty in 36, I think it was, dealing with refugees from then Nazi Germany. Evasion, yes, absolutely. I think there was a clear sense what would be the decent thing to do. It was an intra-European event, so all sides should have been set towards a solution that would offer protection for these refugees, but basically that was not done. So there are many historical precedents that are that we can use to leverage an account of continuity here. So it might be bad, and we might want to denounce it, but we don't need the argument that okay, now it has reached such a level that we're talking about a wholly new phenomenon. I would say that at least. And then very quickly as to your point about well, the upside of safe third country policies creating asylum countries from nothing, basically. Now, at least with these kind of center periphery leverages, you can kind of force or very forcibly invite partner countries into boosting their asylum systems. Now, isn't that great? Isn't that a wonderful addition to the total number of protection spaces? Well, the upside has a downside, because if you are inviting periphery countries to what they essentially deem to be a bad deal, but they have a hard time at backing out of it because there's so much connected to the high politics of asylum protection and migration management for them in their relations to the center. Thinking of EU and Tunisia is a current example, where you could see that Tunisia is probably not too keen to improve its asylum capabilities to a point where it might be used as a safe third country by EU member states or European countries at large. That's clearly not desirable. So you would try to keep on a level that looks like you're cooperating, but in truth, you're trying to avoid the last step of fully moving up to the level of an asylum country that could be a safe third country. Now, that reminds us of something. That reminds us of patterns of so-called unequal treaties under international laws, where you always have the weaker party trying to use informal means and ways to get out of the hard obligations to not carry the weight of the ultimate consequence of observing the law. That would be very interesting for us lawyers to be educated by you political scientists about how that is done, kind of how one could analyze that in a more detailed way. Thank you.
Okay, Frowin, now I look forward to your reactions, and please feel free also to comment on the two other presentations and address the two speakers.
Yeah, it has indeed been very, very interesting for me to listen really from the legal side, and really it has been enriching and gives me some food for thought also for later, to how to interpret, how to make sense of this evolution, and maybe trying to give an answer, but maybe not a very clear answer to your first question. Or I would like to give some more context, because we spoke also about the spread of these policies in the global south. And maybe to comfort us also a little bit, I would really want to show us the bigger picture. I mean, there are also other data set, more recently, that brought a bigger picture on the evolution on the global south. And quite clearly, we see in Latin America an evolution towards more liberalization, but also we have seen a data set showing generally more evolution towards liberal policies in developing countries of Asia and Africa. So we can see that the picture is actually really a bit more complex. I thought first, maybe do we see not the end of the deterrence paradigm, but actually its expansion, as I saw actually the mapping that we have seen. But I think we see really a more complex evolution, and it's not so easy to put this into categories. And I'm very grateful also for the contribution and the input of Damon, for instance, and this distinguishing between hyperlegalism and also obfuscation, because I think specifically the obfuscation part was interesting for me, because I think we often do not take non-action serious. And as much as we cannot not communicate as persons, state cannot not behave towards people and an issue who is there. And I think most recently we have this book coming out from who spoke about the strategic indifference of states in Northern Africa, for instance. And this has been very important and interesting, and also came to my mind when I read Daniel's part. And I think we really have maybe not just one direction to go, but we have some persistence of discretionary approaches in some areas, some strategic indifference, I think that we should take serious. We have some parts which go in a more liberal way, and then we have the spread of these really restrictive elements, and it's not so easy to make sense of it. Maybe what we can say is that indeed access is getting more and more difficult, also on a procedural level, but then we see also a liberalization on the other parts and different parts. And I think this is important because often it's just kind of a level of more and less restrictiveness. And I think we have to think about it different and really to see different approaches and how they have evolved. So I'm not sure if this is really an answer to your first part, but this has been important for me to kind of to contextualize also my presentation. And for the second part, I see absolutely actually the same. In some ways, indeed, these national asylum frameworks has very clearly, you can say, been set up because states were forced to, for instance, join the European Union. And this has been, obviously, you wrote and research about it through politics of conditionality. So they have been forced to set up these asylum laws, also then for other states to adopt safe third country policies. We could think now, for instance, at the current situation, if there's also now a positive side to it. So this is maybe now the situation where we have a lot of people coming from Ukraine to these Eastern European countries that now obviously sort of also benefit from these politics of conditionality in this time. I think this could be a positive view, but maybe you have another perspective on that. And the other thing is, I think we have really to take serious as well the perspective of the states themselves as not only being forced or being requested to set up these laws. It's a kind of master plan to look also at their genuine interests. And maybe it is interesting because the last national asylum law, to my knowledge, I think is by Qatar, being established in 2018, I guess, in the midst of in a very difficult diplomatic situation. So I think they have also, I mean, their own interest to do so, not only to take responsibility, but obviously states have always to balance their national interests on the one side and prevent, I would say, international damage, reputational damage, or they can use this to improve their international standing and reputation. But we have seen in this case, obviously, adopting a law is one thing, but then really accepting responsibility in practice is a completely other thing as well.
Yeah, I think one element that is becoming very salient today is the ideological component of this policy and how much it makes a difference if people and governments and decision makers can identify with the cause of flight and why the people are oppressed and what they flee from or not. And yeah, this is not really directly related to the safe country policies, but it makes a huge difference with regard to the identification with the norms of international protection. There is one question, a more methodological one in the Q&AR. I don't know if you can see it, Frowin. It relates to how you went about with access the information and legislation, and whether you could comment a bit about the challenges that you faced accessing this data.
Yeah, indeed, it has been challenging to look at the laws of 195 countries for many different reasons. Maybe just a very short answer, what I can say is I have written a working paper where I have kind of laid out a bit more in detail the process, how I went through this. But generally, what has been surprising for me is that indeed a lot of laws are accessible. You need different strategies for different regions, how to access them. It's a question, of course, the challenges from the language. Luckily, a lot of laws are translated to English. I can cover German, French, English, and Spanish and Italian. So we had some other possibilities with the people who were engaged. And yeah, I mean, there's a lot of different challenges. I think the most important one is really not to miss out specific laws that have been adopted. And I must say that I was kind of surprised to see that I found it much easier actually to really make the coverage in regions like Africa, where you just do not have this hyperactivism in the asylum law. I think the main difficulty is really when you have a state like Switzerland, like Denmark, who also like Australia, when you have such an incredible number of legislation and amendments. This takes really a lot of time. Often it's easier systematized, it's very well accessible, but this really takes time. So it was really a lengthy process. But in other countries, obviously, when you have like two different laws for the last 40 years who are easy accessible, it is actually not that difficult to find them and to analyze them. Yeah, I think I would stop there because I could talk for the rest of the webinar about the challenges, but I maybe can put in the link for the working paper so that people who are interested
just put it.
More
Yeah.
detail. Perfect.
Yeah, I just put the link. Daniel?
Frowin, I want to ask you a question about your future research. What are your plans? I mean, you've got this amazing data. What are you going to do with it?
I can say what I'm going to do currently is I work, I'm a quality researcher, so I work currently on Switzerland, on Denmark and South Africa. And I try to look at also two different time parts. So I'm interested in one part on the more historical part, so in Switzerland from the late 70s, Denmark also 70s, 80s, and so South Africa in the late 90s, because what we have seen is really that these policies have been adopted very early and we have not really spoken about it. So it was interesting for me to see, for instance, that the policy, the third country policy in Switzerland dates back to the events of 1968 in the Czech Republic. And often we have this talk about the Iron Curtain and then came more restrictions. But there we can see very clearly internally, this has been a situation that came up, an internal memoir that came up in 1969, because they were fearing that too many people came from Austria, and they thought, well, we have to limit this, we have to make restrictions, and let's make this connection a requirement. And this has then put into law just 10 years later, but that's where it dates back. So I'm very interested to see about what are really the main drivers and the origins of this, because I think we have just a very vague idea often. And so this is one part. And the other part is to look at the more newer sides like Denmark, the law in 2021. I think it's interesting to see really the trajectory of these laws. I mean, these are not new ideas. You have made such an incredible research about it to see really the travel of this law through all the centuries and the instances, and to see how it has evolved and changed. So this is very interesting for me to see, and something I would like to do. Of course, I would like to make more research also on to explain the spread of these policies in Southern Africa, but also have some limited time currently. And let's see how far I get there. And we try in the project group with other people who are more versatile with quantitative methods also to make a general quantitative paper kind of explaining on this way what are the mechanisms, because obviously you have to limit yourself drastically when you work qualitatively.
That sounds very fascinating. Yeah, I mean, for me, that question of what the mechanisms are driving is very, very interesting. And particularly if we're serious about trying to counteract their spread, understanding why countries adopt these policies, the forums in which these happen. Is it just, is it all just, a particular country from the center putting pressure and on them, or there are other policy networks at work here? Are like-minded countries getting together and sharing ideas independent of any pressure they might be under from some countries at the center?
Frowin, maybe you can address this question, because you have these surprising cases from the global south where one would not think that they are under direct, also if it's singular countries that Angola, you said, for example, what could be the mechanisms there?
Yeah, it's not so easy to answer, and it's also I'm a bit uncomfortable because I'm still on, just the research is still ongoing, but maybe just a small remark from Switzerland first. Maybe what I found also a bit funny there is to see it was also kind of misunderstanding in some way. When Switzerland adopted the safe country of origin policy, you can read in the parliamentary debate, but we're not the first one. Sweden did it, Canada did it, but that's not correct. And going through the archive, you can also see that it is to some point also the diffusion through a misunderstanding, misinterpretation, and transformation, sometimes also through the language, right? So a person comes from, then ends up with, originates from, or has been in, when they compare about the policy in Sweden. And this is then a misinterpretation of the policy that has been. So kind of misunderstanding, diffusion, or influence through misunderstanding has been maybe not the most important, but an interesting element for me to see. And then indeed it has been interesting, I think, that we often look, I think, we from the global north, so to say, on the global south, is to say, well, the area of influence of the European Union and other countries, and there you can see, well, actually these are rather regions where we don't see this. And I think the easiest is just to say what it is not. Where we see that the European Union had a strong effect, kind of top-down effect also through politics of conditionality and so on. This is certainly not a top-down effect from similar organizations such as the SADC organization is not advocating this policy, is not as strong as there. And I can see rather, for instance, when I look at South Africa, more like really interest-based diffusion, I would name it currently. And yeah, Angola, you mentioned, it's an interesting case because Angola has been among the first countries that Switzerland, for instance, has put on the list saying, well, Angola is a safe country of origin. So if someone from Angola comes, we'll reject it. And now 20 years later around, Angola is taking up this policy and using it in their way, maybe saying, well, when someone comes from a specific country in their region, that's a safe country, so we're going to reject it. So that's really an interesting way in which it will go. And it's not that easy to see exactly what is the mechanism behind, but certainly not top down. And maybe we should also ask why it hasn't been prevented, for instance, because so many of these policies have widely spread, but very, very rare, few cases there have been where the countries have then decided to go back and not to use them anymore. Like I just mentioned, Canada, for instance, just pulled out from the Safe Country of Origin policy. But these are really, really rare cases, I think, and also worthy to ask.
And I guess one other interesting dimension would be whether they're actually being used. I think, you know, we in Australia, we had the policies on the books for a long time, and there was no countries designated as safe. And I know it would be a very difficult undertaking in terms of research, but it makes me wonder how many of these countries just have the policy on the books and don't actually implement it in practice.
Maybe if I can jump also to look at the change in the countries that have been designated as safe, whether there's a pattern there that we also see a downscaling of standards in the conditions for being determined as safe. I don't know, Frowin, if you wanted to address this.
Yeah, maybe just shortly. Indeed, it's difficult to say, but what we can say is, for instance, that also countries that do not have them in the law, for instance, Botswana, are using them extensively in practice. So we can see, for instance, the latest report from UNHCR is, I think, quoting a number higher than 90% of the applications have been rejected based on a safe third country policy. So these are important. Often it's difficult also to get really good information on the statistics. And I get, for instance, mixed results and answers regarding South Africa. Some say, well, yes, it's very important. It is used extensively. And others say, well, actually, it's just when you have such a high number of rejections, over 90%, when you have so many issues and problems with access, that is just not really making a big difference. So it's really different. And in some cases, also in the European case, it has been interesting by Claudia Engelmann, maybe, for instance, who made a research, and she showed that in the case of Malta, for instance, Malta used added a lot of countries to safe country of origins where they had no applicants from at all. So it seemed that they were mostly like copying from the UK and not really that it has a wish to affect just kind of what can we do that it kind of is right. So they have looked very much to this. So there we don't see really a very strong effect in this direction. Yeah, and maybe one question for me it has been really fascinating. I need more really time to think about is the presentation of Gregor Noll is about the more and more informality also that you mentioned, and yeah, and what I wanted to ask is what I see. I mean, what you see very clearly is just the convergence. The convergence of the asylum laws around the world, and in getting, I would say also in this way, yes, we can see more informality. They are less formalized when we look at newer regulations. You mentioned the EU-Turkey agreement, but we can see also very strong convergence of laws, and the law that spread are generally more complex than the one who have been adopted very early on. So how do you How do you see the interplay of these two different evolutions?
Oh, that's a great question, Frowin. If I can try to pick up one handle, and here I'm taking my cue from you, Daniel, because you said that advocacy is important to raise the question whether, is there or is there no compliance with international law when it comes to the implementation of safe third country policy? So that's something that should be discussed in a democratic forum with the public. It should be an issue for more than just experts. It just struck me that this is a hard one, how to formulate that in a fair way, but academia and civil society have been advocating for kind of more foolproof laws that would take full account of the binding norms of human rights law and refugee law, and that has also been part of it has been a driver for more complex laws being made without necessarily having commensurate gains when it comes to access to justice or kind of a predictable delivery of fundamental rights and stuff like that. So yes, we are complicit. We, pointing the fingers back to academia, which has a role in that, we are complicit in making laws more complex, because at the end of the day, we can just ask for amendments, for formulations being entered as reservations, as clawback clauses into restrictive laws on the workbench. So we do not have the power to say, well, now it has attained such a level of complexity that the very complexity itself seems to be a threat to the rule of law. And we no longer want that legislation. That's not within the reach of advocacy to do that, and to do that successfully. So we do have a role in making stuff more complex and making legislation more complex. I'm not saying that we are the main culprits in academia or in civil society, but there is a kind of a relationship here. Now, kind of a second attempt at a response to your comment would be also drawing on your critique of hyperlegalism, Daniel. Would it be hyperlegalist to argue, if we look at Frowin's charts of the spread of these policies, and we are considering how old they are, your story of Switzerland preparing to basically seal itself off versus refugees from Czechoslovakia. That was very telling. I mean, it's really old, and you could go back to Evian, and you could go back earlier in time. So, with that in mind, isn't there a state practice, to quote Article 31.3b of the Vienna Convention on the Law of Treaties, where it shall be taken into account, together with the context, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. Otherwise put, if you read the 51 Refugee Convention, would it not have to be read in the context of the spread of those policies as an expression of practice in the application of the 51 Convention, which establishes the agreement of the parties regarding its interventions? Now, I could mount a hyper-legalist argument in defense of the 51 Convention, saying it is not the case that all states that have signed or otherwise become bound to the 51 Convention have participated in that practice. So I would really mount a kind of a very technical, very detailed argument, but now on the other side in defense of the 51 Convention in its kind of old version, unrestrained by safe third country practices. Perhaps I should ask you, Daniel, would you accept that as an argument that is a bona fide argument, although it is hyper-legalist in its technique of delivery?
So which part would I accept? The first part about the the state practice as interpreting, or then the defense of the fact that states haven't?
Yeah, more the defense. I was more interested that if I would rush out to the defense and say it's not really practice in the Vienna Convention sense because there are too few states. I'd be interested to hear what you think.
No, look, I think you've touched on a really interesting point that I hadn't really turned my mind to, which is the fact that maybe us as refugee lawyers often engage in hyperlegal arguments, trying to expand the scope of protection offered under the convention, and so maybe we're just as guilty as the states are sort of engaging in this practice. I mean, I think to add to the defense, I would say also that state practice is one tool of interpretation. It's not the only interpretation, and in particular, I think the biggest, and for me, the biggest legal argument here against the safe country practices is that if you take an integrated approach to international law, if you take into account other human rights obligations, particularly things about the right to family, and other human rights, it becomes much harder to defend these policies. Really, they tend to focus only on non-refoulement. That's all. And they're like, as long as non-refoulement is protected in the other country, then the country is safe. And that is a very selective reading of the international obligations.
No, I would agree on that. But in the defense of hyperlegalism, it's really weird that I'm doing this here now. In defense of hyperlegalism, we probably should acknowledge that we need these resources. And that's the tricky part when we're thinking in terms of advocacy and public engagement. You need to get fairly technical to say, well, it's actually the case, yet, right to family life, even though there's a kind of a downgrading tendency in safe third country corporations, you still have enough of it in order to make it very hard to bona fide implement safe third country arrangements with a full respect.
If I may just step in, it's a detailed question, but it also struck me with the notion of hyperlegalism, whether it has to be illiberal law that is being produced by this hyperlegalism. So is something lost? Because when you contrast hyperlegalism with legalism, the first point for legalism is that there is the moral dimension to the law that makes it legitimate. And you don't have this element in your definition of hyperlegalism. So I was wondering, is hyperlegalism illiberal, detached from the moral basis, and in that view somehow illegitimate, but for whom, right? Because the concept of legitimacy, of course, is a complex one, and it could be that there is a new moral basis being invented for what you term hyperlegal, that could be illiberal, but different.
No, that's a very interesting question, Sandra. I think the morality component there of legalism is not so much external. It's just that the rules being followed is a good thing. That's the moral claim there. And then hyperlegalism takes that, but then makes the rules completely malleable. And so the whole thing about no consistency of rule following being moral good, and he tries to gain the rhetorical benefits of that while completely changing what the content of the rules are to suit governments. And I don't think it necessarily has to be taking a frame of illiberal or liberal. I think it's just that malleability, like that bad faith approach of changing the content of the rules, yet trying to gain the benefits, the moral benefits, saying we're following the rules. That's the issue.
Yeah, thanks. I think that was a very useful clarification. Yeah, we have, I think, exploited our time. We have no questions in the Q&R. Someone would like to comment on the last point? Otherwise, I would say that we can leave it here for this webinar on the spread of safe country policies. And I think this, yeah, especially the legal invention and creativity and challenges involved have been really spelled out very well by our two commentators. And Frowin, for sure, this research is a great contribution to the international community. And my personal hope is that you make a lot out of your data yourself, that you really exploit your knowledge. And I must say, I have a great respect for your honesty and care in the interpretation of these phenomena, and your desire not to be too broad brushed and to do justice to what is happening in the concrete cases. But of course, this makes it difficult then to have a large N analysis if you want to do justice to each individual case. So that's a clearly trade-off. So it's good to have both the qualitative and the quantitative parts in your research. Yeah, so I'm just very grateful to the three of you for this conversation, and always very happy to be able to read you as well. Thank you for your great work, and see you in another context again.